Lysandro Vostatek, 25M2298. Mr. Vostatek is here. It was scheduled for a probation violation hearing on the 9 o'clock docket. Mr. Vostatek, I know part of the different discussions we've had about the case was that you were going to hire an attorney or apply for the public defender.
Good morning, and I'm appearing pro se
Okay.
here today.
Okay.
Yes,
You ready to proceed for a hearing, Mr. Vostatek?
yes, Your Honor.
Okay. People ready?
Your Honor, the people would like to call Officer Zorb, please.
Okay. You come on up to the witness stand, please. You raise your right hand. You swear affirm on a penalty of perjury the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth. Okay, go ahead and have a seat. Go ahead.
Good morning.
Good morning.
Would you please state and spell your name for the record?
Alexis, Alexis, Zorb, Zoerb.
Ms. Zorb, who is your employer?
The 21st Judicial District Probation Department.
And what is your occupation?
I'm a probation officer.
And how long have you worked there?
About a year and a half.
And did you have Lysandro Vostatek as a client?
I do.
Do you see him in the courtroom today?
I do.
Can you describe what he's wearing?
A blue button-up collared shirt
Can you describe where he's sitting?
right over there.
Can you describe his hair color?
I don't think identity is really an issue on a PV complaint. I know who Mr. Vostatek is.
Oh, thank you, Your Honor.
You're welcome.
Was he your client in Mesa County, Colorado?
Yes, he is.
Your Honor, may I approach?
Yes.
Do you recognize what I handed you?
I do.
What is it?
It's his county court plea agreement.
How can you tell?
The title at the top.
And to your knowledge, was Mr. Vostatek on supervised probation for 12 months?
Yes, he is.
Okay. Would you say this is a fair and accurate representation of the plea agreement to the best of your knowledge?
Yes, it is.
Your Honor, the people moved to admit what has been marked as People's Exhibit 1.
Do you have a copy for Mr. Vostatek so he can see what the exhibit is?
I do. Thank you for the reminder.
Any objection, Mr. Vostatek?
No.
Exhibit 1's admitted?
Your Honor, may I approach again?
Yes.
Thank you.
Well, actually, I do, Your Honor. It appears that this is backdated a year, this plea agreement here.
I have January 6, 2025.
Yeah, it's 2026.
What's that?
It was supposed to be 2026,
Right.
not 25. So this is pretty much,
That goes towards its weight, not its admissibility. If there was a Scrivener error on the creation of it, my plea agreement that I have in the file has my signature is the date that it was accepted in the findings of the court as voluntary acceptance on January 6, 2026. Form that's attached to the plea agreement.
all right, it appears the district attorney also backdated it a year, 1/6/25.
Yeah, they made a mistake, Mr. Vostatek. It was a plea agreement that you entered on January 6th of 2026.
Yeah,
Go ahead, Mr. Cross.
There's another error right here also.
Again, you'll have the opportunity to cross-examine the witness.
Oh, yeah, I'll just take on this.
That's okay.
Ms. Zorb, what did I just hand you?
The sentencing order for this case.
How do you know what it is?
It says sentencing order.
Is your name on it?
It is.
Is this a standard sentence order form?
It is.
On page 2, are those standard conditions of supervision?
They are.
And do you recognize Mr. Lysandro Vostatek's initials in front of all of the conditions on page 2?
I do.
What is condition number 7?
That he will submit to drug and alcohol testing as directed by the probation officer.
Okay. And is this sentencing order fair and accurate to the best of your knowledge?
Yes, it is.
Your Honor, the people moved to admit what has been marked as People's Exhibit 2.
Do you have a copy from?
Yeah, I do.
Okay. Any objection, Mr. Vostatek?
No objection.
All right, Exhibit 2 is admitted.
Your Honor, may I approach again?
Yes.
Thank you. Do you recognize the allegations in the complaint that I handed you?
I do.
What are they?
What are the counts?
Yeah, like what are the accusations and the counts or whatnot?
That
I
you,
can read the complaint.
Okay.
I don't need her to read it to me.
Sure. Are those allegations accurate to the best of your knowledge?
yes, they are.
Your Honor, the people moved to admit People's Exhibit 3.
Mr. Vostotek? Any objection to the admission?
No objection, Your Honor.
Exhibit 3 is admitted.
Your Honor, may I approach?
Yes.
What did I just hand you?
My narratives from the time I've worked with on this case.
How do you recognize it?
I printed them and emailed them.
And you wrote those narratives?
I did.
Okay. Generally, what probation violations are outlined within?
Missing his drug tests and failure to complete or comply with community service.
And are those accurate to the best of your knowledge and recollection?
They are.
What conversations are outlined within?
That we do typical check-ins, talk about where he's living, what's going on, and then I'll direct him to go take a UA and start his community service hours.
And does that report contain an accurate record of those conversations to the best of your knowledge and recollection?
It does.
Your Honor, the people moved to admit People's Exhibit 4.
Mr. Vostotek?
No objection.
Exhibit 4 is admitted.
Ms. Vosatek Ms. Zorb, did Mr. Vosatek miss any drug tests?
Yes, he did.
Okay. Did he complete his useful public service hours?
He did not.
And is that a violation of his probation?
It is.
Nothing further, thank you.
Mr. Vostotek, any questions for Ms. Zorb? You can either do it from the table in front of the microphone or the podium, whichever you prefer.
No, I don't have any questions
Okay.
for Ms. Zorb.
Thank you, Ms. Zorb. You can have a seat. Do you have a copy of Exhibit 4 for me? I have all the other ones. You can give those to me, Ms. Zorb. Thank you. Which was Exhibit 4?
That was
Any other witnesses for the people?
I'm sorry, would you please repeat that?
Any other witnesses for the people?
Your Honor, the people would like to call Mr. Vosatek.
Okay. Mr. Vostotek, if you can come on up to the podium or the witness chair, please.
Just ask him. Do you have?
Just over there by the chair, so you're in front of a microphone.
Okay.
If you could raise your right hand, please. I swear affirm under penalty of perjury, the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth. Okay, will you have a seat?
Says no, then you might need it.
Sure.
Go ahead.
Thank you. Good morning.
Morning.
Mr. Vosatek, did you have a chance?
Could you state your name and spell your last name for the record, please?
Sure. Lissandro Vostotek, Lisandro and Vostatek.
Thank you.
Mr. Vosatek, did you have a chance to review what was marked as People's Exhibit 1 or your plea agreement?
I did.
Okay. Did you sign that agreement?
I did.
Okay. And on that agreement, it required 12 months of supervised probation?
It did.
Did you get a chance to review what was marked as People's Exhibit 2 or your sentence order?
I did.
On page 2 of that document, there were a list of terms of your probation. Did you see your initials on page 2 of that document?
I did.
And as part of that document, were you required to submit to regular drug testing?
Yeah, I did. Yeah. Yes.
Did you report to drug testing on January 20th, 2026?
I did not.
What about on January 30th of 2026?
I did not.
February 17th of 2026?
No.
April 7th of 2026?
No.
May 12th of 2026?
No.
Did you complete any useful public service hours?
No.
Okay. Nothing further, thank you.
Yes, can I grab my papers?
Sure, yeah, that's fine. Yep.
So, I'm pleading not guilty to this probation revocation complaint in case number 2025M2298. I filed an emergency motion to dismiss under the fruit of the poisonous tree doctrine at the clerk's counter this morning, and I have a date stamped copy here for the record. So this probation status is built on a void foundation proven by the court's own minute order from August 26th of 2025. The first involuntary detention and the denial of due process. The minute order logs me as a failure to appear, but simultaneously notes I was detained in this building by the sheriff's office on a warrant, proceeding ex parte while knowing I was held in custody inside the building is a direct deprivation of due process. That is the primary poisoned tree. Second, unauthorized practice of law. Well, that same minute order shows non-attorney Ian Gershman represented an LLC pro se under CRS 13-1-127. A non-attorney cannot represent a corporate entity, rendering the underlying judgment void ab initio. And under the fruit of the poisonous tree doctrine, the probation revocation in case number 2025M2298 is constitutionally tainted fruit. I demand this court dismiss the revocation complaint immediately or stay these proceedings until I am provided 100% proof of jurisdiction to proceed.
Thank you, Mr. Vostitek. Anything else?
No, that's it, Your Honor.
Okay. You can have a seat, Mr. Vostitek.
Thank you.
Any other witnesses or evidence from the people?
Nothing further, Your Honor. Thank you.
Mr. Vostitek, other than your testimony in response to the direct examination, any other witnesses or evidence?
No, Your Honor.
Mr. Vostitek, any further argument from you other than what you've indicated you filed today?
No, Your Honor.
Court made the following findings of fact and conclusions of law relative to the amended complaint that's been filed in the case. The court finds that based upon his own admission, Mr. Vostitek did not participate in testing on January 20th, which is count 1, January 30th, which is count 2, February 17th, which is count 3, hasn't completed useful public service hours as is reflected in count 4, did not participate in testing on April 7th, which is count 5, or May 12th, which is count 6. The Cron notes that I have that's indicated the last communication, June 16th, again indicated he's not completed or signed up for any UPS hours. Did not address or direct defendant. PO did not address or direct the defendant take a UA during apartment. Which Mr. Vostitek is clearly not going to take anyway. Mr. Vostitek's response to the amended complaint is to indicate that nobody had something about legal authority regarding the arrest. A warrant was issued on August 26, 2025. He was detained on the warrant, seen on videos, and on August 27th, 2025, and given a personal recognizance bond by me to get out of jail, which is where he got credit for 1 day served from being remanded at the courthouse and then let go. Mr. Vostitek, during the inquiries of the court on the plea agreement on January 6, 2026, he correctly points out that both he and the DA signed it as 2025. What I go by as well is when I write down that there was a knowing voluntary waiver of rights and entry of a plea was the correct date of January 6th of 2026, which is also reflected in the Register of Actions and the minute orders from my courtroom on January 6, 2026. There wasn't a claim at that time that it was an improper year or that it wasn't him or that it wasn't signed on that particular day. What is common in court filings is that most people about January 6 forget to continue to write things for 2026 and do the previous year. So it's not uncommon to do that, but that does not void the plea agreement, the obligations, and the sentence that was imposed as is reflected in the terms and conditions of probation. That was filed by probation on January 16, 2026 and ordered as a court order on February 4th, 2026. Mr. Vostitek has violated the terms and conditions of probation as is reflected in the amended complaint, which is sustained by the court. Any sentence recommendations, Mr. Cross?
There was something in the notes, right?
I'll just,
Broken term for
for the findings of the court anyway, I haven't seen the pleading. If it was filed this morning, Mr. Vostatek, I'll look at it when it gets to me. Even though it's filed in the clerk's office for your benefit, it goes through a clerk review in the clerk's office to make sure it's the right case number assigned to the right division. And then it's forwarded to my inbox once it passes that. So something filed in the morning doesn't technically get to my inbox until probably the afternoon of that day. My clerks can go in and do clerk review, into clerk review and send it to me directly, but something that's filed this morning, particularly before a 9 o'clock hearing, would not be in my inbox for me to review. I'd note that the arguments that you have or that you've discussed here are the same arguments that you've been filing with the court under some misnomer of some corporate entity under an LLC, which is the same sovereign citizen gibberish I've been dealing with for 19 and a half years. So I'll deal with the motion when I see it, when it's provided to me, but it does not void the obligations that you have on probation, the sentence that I impose, and the requirement to do not only UAs, but also useful public service. Anything, Mr. Cross?
Yes, Your Honor. Our office had a chance to talk to Ms. Zorb, and she thought that direct jail would be appropriate. Given that probation is not working, she recommended 45 days of direct jail, and I believe that would also be appropriate. Revoke and end with that jail term.
Okay.
Thank you.
Mr. Vostatek, any recommendations for sentencing?
Yeah, just the reinstatement, I guess, of probation would be what I would say. Well,
Are you going to do a UA? Are you going to do the useful public
yeah,
service?
I'll do them.
How do I know that you're going to do them when you haven't done one of them since I placed you on probation in January?
Because I'm looking you in the eye and telling you I'll do them.
You're going to do them.
I'll do them.
And the UPS hours.
And the UPS hours.
Okay. What I'll do is I'll order revoke and reinstate probation for a year with 90 days of direct jail, suspended on the condition that you do the UAs and you successfully complete probation and the useful public service hours. If I get a report to the court from Ms. Zorb that you have not signed up for or started any useful public service hours in the next 30 days or deny or miss a UA, the report to the court will make it a 90-day direct jail sentence.
Okay.
Okay?
You got
So
it.
if you do everything you have to, there's no jail. And I'll accept your word, Mr. Vostatek.
All right.
Today, you're looking me in the eye, I'm looking you in the eye, that if you do what you're supposed to do, you don't go to jail.
All right.
Okay?
Yes, Your Honor. Yep.
So you need to meet with Ms. Zorb, go over those same terms and conditions. It's exactly what you signed when you met with her the beginning of the year. Again, get the information directly from her as far as where you go or what you do to do the useful public service hours. I know in the past, Mr. Vostatek has had financial issues. It's reflected in the narratives about not being employed because he works for his living, for the place that he lives. So I'm fine with not or waiving a UPS fee for Mr. Vostatek so that there's not a financial barrier for you doing the useful public service. Since you live up on the Mesa, do you still live up there, Mr. Vostatek?
I do.
That's something, Ms. Zorb, as far as a nonprofit up there where he can do that. It's not my intent that you have to come down to Mesa County to work at Goodwill. The intent of the community service is to benefit the community where you reside. So I'm willing to be flexible on those things so that it's not a financial barrier and it's not a logistics barrier for you to do the useful public service. But my expectation is that Ms. Zorb will file a report in 30 days that I get to read that says that you've signed up for UPS hours and you've complied with the UAs.
Okay. Yes, Your Honor.
Anything else, Mr. Cross?
Nothing further, Your Honor. Thank you.
Okay. You get him back, Ms. Zorb. Thank you, Mr. Vostatek.
Yeah.
Appreciate your time. I'll review the motion that you filed when I get it, okay?
All right.
I'll probably, Mr. Cross, for your benefit, I'll let the DA file a response to it.
Detention hearing on warrant 2026-273-0102. Appearances of counsel, starting with the state.
Morning, Your Honor. Assistant Prosecutor Capello for the state.
Holly Bitters on behalf of Quentin Hunt.
Okay, good morning, or it's still morning. Good morning to both of you. Good morning, Mr. Hunt. So you've gone over his charges and first appearance rights. He understands both, Ms. Bitters?
He does, Judge.
Okay, I'll mark the first appearance complete. You've gone over his detention hearing rights as well?
Yes.
Mark the detention hearing rights advisement complete. Moving to what the court has in its file, the court has the complaint warrant package, including the affidavit of probable cause and the preliminary law enforcement incident report. We'll mark that as S1, Mr. Capello.
Yes, please, Judge.
S1, the court also has the PSA, which has a 4 on the failure to appear scale, a 5 on the new criminal activity scale, and no release recommendation. I'm going to have pretrial services explain this one to me, how it's not a 6-6, but we'll put that aside. You want to mark that as S2?
Yes, please, Judge.
It's S2. And then the notice of motion for pretrial detention supporting certification, mark that as S3.
Yes, please, Judge.
Anything else you want to mark?
Nothing, Judge.
We'll
Thank you.
move S1 through S3 into evidence.
Yes, please, Judge.
S1 through S3 are in evidence. Any defense exhibits?
No, thank you, Judge.
I think so, but we're moving along. So probable cause stipulation, Ms. Bitters?
We'll stipulate.
Although the defense is not contesting probable cause, the court still must make an independent determination regarding the issue of probable cause. The United States Supreme Court has defined probable cause as a well-grounded suspicion that an offense has been committed and a well-grounded suspicion that the defendant is one that committed it. It's Gerstein v. Pugh, 420 U.S. 102, 1974. Selective probable cause in this case, of course, they have the opportunity to review the complaint warrant package, which includes the affidavit of probable cause and the preliminary law enforcement incident report, which were marked and moved collectively into evidence as S1. Courts also take into consideration there's a stipulation by between the parties for the purpose of this hearing and this hearing only. Based upon those things, the court finds the defendant an eligible offender committed the charged offenses at the probable cause or well-grounded suspicion level. Having found probable cause, the court's going to move to the detention determination. Here, there's a presumption of release. State has the burden of proving detention by clear and convincing evidence. PSA has no release recommendation. I understand that the defense is consenting. If that's the case, I can just move right into my ruling. Any objection, Mr. Capello?
No objection, Your Honor.
Ms. Bitters?
No objection, Judge.
Okay, thank you both. So before the court is Quinn Hunt on warrant 2026-2783-0102. State filed a motion for pretrial detention. After conducting a hearing, the court again finds that state has established probable cause. The defendant is an eligible defendant. He committed the charged offenses at the probable cause or well-grounded suspicion level. That's based upon S1, which is the probable cause affidavit and the preliminary law enforcement incident report and the stipulation between the parties for the purpose of this hearing and this hearing only. With regard to the detention determination, court notes it's by consent, but the court still must make independent findings. Court finds by clear and convincing evidence that no amount of monetary bail, non-monetary conditions, or a combination of monetary bail and conditions would reasonably assure defendant's appearance in court required and the protection of the safety of any other person in the community, and the defendant will not obstruct or attempt to obstruct the criminal justice process. And therefore, pretrial detention of the defendant is hereby ordered. In making that determination, the court considered each and every statutory factor and more. Court considered the nature and circumstance of the offense as charged. Defendant has been charged with third degree knowingly using a stolen credit card, third degree knowingly receiving stolen property, and third degree attempting to use a stolen credit card. The charges arose out of the facts that as set forth in the affidavit of probable cause, was just incorporated by reference. At the time of defendant's arrest, defendant had 51 pending charges, which included multiple counts of burglary, theft, identity theft, credit card crimes, criminal trespass, and more. Defendant had 18 prior disorderly persons convictions, which included multiple thefts, identity thefts, and criminal trespasses. Defendant had 68 prior indictable convictions for robbery, multiple burglaries, multiple thefts, multiple receiving stolen properties, multiple credit card crimes, multiple larcenies, and multiple escapes.
I'm surprised he was on the street.
That's the longest record I think I've ever seen. It's unbelievable. Two of defendant's prior convictions constitute violent crimes for robbery and armed burglary. Defendant has 26 prior sentences of incarceration of more than 14 days, mostly in the New Jersey State Prison. Defendant currently is on probation. Not sure how he got probation. Defendant is essentially a walking crime spree at this point. Defendant definitely represents a danger to persons and the community. Defendant has escape and identity crime convictions. He seemingly has violated his probation. He clearly represents a risk to obstruct. Defendant has 6 prior failures to appear. Defendant has 7 active warrants for his arrest when he was arrested. Defendant has a detainer when he was arrested. Defendant is a 4 and 5, as already stated. There's no release recommendation. The court gives it overwhelming weight. With regard to the other factors, the court considered the weight of the evidence against the defendant, including personal observations of law enforcement, statements of the witnesses, the victim, the witnesses, statements of strike that video, including body worn camera footage, surveillance camera, physical evidence, the wallet and credit cards. Court considered his history and characteristics. Defendant has an important prior criminal history with 68 indictable convictions, 18 disorderly persons convictions, 2 violent convictions, 26 sentences of more than 14 days incarceration, He was on probation at the time of his arrest. He had 51 charges pending at the time of his arrest, with 6 failures to appear, 7 active warrants, and a detainer. There are no conditions.
Because anyone who's violated these conditions this many times in less than 1 calendar month, to me, shows me they don't care what a judge says. Do you understand that?
Yes, sir.
So again, I want you to be clear. You're lucky that it's not my choice today. It's somebody else's choice. And that somebody else wants us to release you with these conditions. You're to check in once per week. Is that somehow not clear?
No, it's clear.
Okay. You're not to get rearrested. Is that somehow not clear?
Nope.
Is that clear?
It's clear.
Okay. Now, this person who we haven't even gotten to yet, the one you're supposed to have no contact with, you're supposed to have no contact with them. Is that clear?
Yes.
And if you violate these conditions again, I will gladly lock you up waiting for court dates with no date in the future. Is that clear?
Yes.
Okay. So we're going to keep you on level 3 because today it's somebody else's choice and not mine. Is that clear?
Yes.
If I see you in the future and you say you didn't understand, would that be wrong because you clearly do understand now?
I understand.
Perfect. The system's working. You have a new charge. W-26-687. You're charged with contempt by violating a domestic violence restraining order under 2C-29-9B. You should have been provided a copy of the charges. If you weren't, you'll get it by the end of the day. Do you understand?
Yes.
These charges carry a maximum penalty of 6 months in jail, a fine of up to $1,000, possible community service, restitution, probation, or all of the above. Do you understand?
Yes.
You have the following rights. You have the right to remain silent. Anything you say may be used against you. You are presumed innocent unless the state can prove your guilt beyond a reasonable doubt. You have the right to be represented by an attorney, and you have been found eligible for representation by the Office of the Public Defender. Mr. Rohr,
Bill Rohr, Public Defender. We enter a plea of not guilty.
thank you. Sir, are you a veteran of the United States military?
No.
Thank you. I have another question. It's a long question. Just wait for the end before you answer it. If you're not a citizen of the United States, and if you plead guilty or are convicted of certain offenses, it may result in you being deported from the United States, or it may prevent you from being readmitted if you leave voluntarily, or it may prevent you from ever becoming a naturalized American citizen. Do you understand that you have the right to seek advice from an attorney about the effect a guilty plea or finding may have on your immigration status?
Yes.
Thank you. Prosecutor, your position on Mr. Pizarchik.
State recommends PML 3. No victim contact with initials EP. That's Echo Papa. No weapons, no stalking. The matter was referred to a grand jury.
Thank you. Sir, do you know somebody with the initials ET?
EP, yes.
You're to have no contact with that person as a condition of being released. Do you understand?
Yes.
You're on pretrial service monitoring now, so you know how that goes, correct?
Yes.
We're going to continue you on level 3 on this new charge as well, which means you'll check in once per week. Do you understand?
Yes.
You cannot get rearrested for any reason. You cannot miss any court dates. You cannot miss any check-ins. Do you understand?
Yes.
You cannot possess weapons of any kind as a condition of your release. Do you understand?
Yes.
You cannot stalk or try to reach out to EP in any manner. Not live, not virtual, not through a third party. Nothing at all is permitted. Do you understand?
Understood.
Continuing to violate that restraining order would be considered a violation of this as well. Is that clear?
Yes.
Now, in this case, sir, new court date has not been set. Your case is being referred to the grand jury. You and your attorney will be contacted once they make a decision. Do you understand?
Yes.
Sir, I spent extra time with you today because I'm trying to get through to you that if you continue to violate these conditions, there will come a time that you're just going to be locked up waiting for court dates. Is that clear?
Yes.
So you're being released today. Take this opportunity, grasp it by the horns, follow these conditions, and stay out of jail. Is that clear?
Yes, sir.
Do you have any questions?
Yes, I do.
Go ahead.
Okay.
But don't talk about the facts.
No. My address is 1, correct?
Well,
Where I live.
I'm gonna stop you right there. I don't like to put addresses on the record. Let's go off the tape for a minute.